Welcome to the AI Brief from the YPO Technology Network. I'm Stephen Forte. Something happened on Sunday that almost nobody's Monday leadership meeting mentioned because the news cycle was busy grading earnings. On today's episode, the AI disclosure rules that became enforceable law on two continents on the very same day, the three courtroom doors that quietly closed the same week, and the company that managed to end up the odd one out twice in 7 days. Here's the promise for the next few minutes. By the end, you will know which of your AI touchpoints acquired a legal label requirement this weekend, what ignoring it costs per day, and the one question to put to two of your executives this week, while this is still an operations task and not a legal event. Start with Sunday. On the 2nd of August, California's AI Transparency Act became operative. If a generative AI system is publicly accessible in California and draws more than 1 million monthly visitors or users, its provider now owes the public two things: a free tool that can detect whether content came from their system, and provenance marks in the AI-generated images, video, and audio it produces, a visible label and an invisible one embedded in the file itself. The penalty is $5,000 per violation, and every day of non-compliance counts as a separate violation. Enforcement belongs to the state's attorney general, California's top government lawyer, and also to city attorneys and county council, which multiplies the number of offices that can bring a case. The very same day, an ocean away, Article 50 of the European Union's AI Act reached its enforcement date. Chatbots must now disclose that they are AI. Deepfakes and synthetic media must carry machine-readable labels. The Commission's AI office and national market surveillance authorities acquired the power to act, with fines up to 15 million euros or 3% of global revenue for these breaches. Keep that tier separate in your head from the headline number you may have seen. The 35 million euro 7% tier is reserved for outright prohibited practices. Different shelf. Last Tuesday, we told you that Europe's AI delay does not cover you, that the postponed half of the AI Act was the heavy machinery for high-risk systems, and the transparency half stayed on schedule. This is that half arriving. Note the choreography because there was none. Two legal systems, two continents, the same deadline, the same Sunday, and no coordination between them. When two regulators land on the same day by accident, that is not a coincidence. That is convergence. And convergence is what a new baseline looks like while it is forming. One design nuance and genuine credit where it is due. Brussels wrote a grace period that runs to the 2nd of December, but only for systems and content already on the market before Sunday. Anything you ship new must comply now. That is how you write a transition without writing a loophole. California, for what it is worth, offers no runway at all. Underneath the statute in Europe sits a voluntary layer, a code of practice, the compliance rulebook the Commission negotiated with the industry. 26 major model providers signed it: Anthropic, Google, Microsoft, OpenAI, Mistral, the names you would expect. Meta did not sign. Meta's stated position is that the code goes beyond what the law itself requires, and that is a coherent legal argument. But step back 1 week, the market just marked Meta down for AI spending it could not yet show a receivable for. Days later, Meta chose to be the only major lab standing outside the transparency code. Two independent judgments in 1 week. Same posture both times. Now, here is where this reaches your company because you might be filing all of this under my platform vendor's problem. The statutes disagree. The California duties flow down to licensees, and the European ones attach to what your business puts in front of users, not just to whoever built the model. If your marketing team ships AI-generated video or imagery to audiences in Europe or California, and if it ships anything programmatic, it does. If your website runs a customer-facing chatbot that speaks to Europe, if your product embeds a licensed generative model anywhere a customer touches it, some part of your company acquired a dated legal obligation this weekend. If you're listening in Munich or Madrid, this is your own regulator and your counsel is probably ahead of me. If you're in Sao Paulo, Sydney, or Chicago, you may have filed both of these laws under foreign news. The question is not where your company sits. It is where your content travels. And content travels everywhere by default. Picture a consumer brand CEO whose agency ships 40 AI-generated ad variants a week into programmatic channels across 40 markets. Ask that CEO who owns the label decision, and the honest answer today is nobody. And the approval chain was built for brand safety and legal claims, not for provenance law. That CEO does not have a technology problem. They have an unassigned signature. And while the statutes arrived at the front door, the courts spent the same week closing the side doors. In Munich on the 31st of July, the regional court ruled against Suno, the AI music generator, in a case brought by GEMA, Germany's Music Rights Society. The court held that training on copyrighted songs can infringe European copyright even when the training happened in the United States because reproduction occurs in the model and again when outputs reach German users. It rejected both American fair use and Europe's own text and data mining exception as defenses. GEMA's claims were largely granted an injunction, disclosure, and an entitlement to damages not yet quantified. And the judgment is not final. Suno is weighing an appeal. It is the first German ruling on AI music training, and the same court sided against OpenAI over song lyrics last November. That is a pattern, not an accident. Train where the law is friendliest just stopped working as a strategy. In New York, a federal judge let Reddit's core claims against Perplexity and its data supplier proceed, the claims saying that scraping past a site's technical barriers can violate the DMCA, the United States' digital copyright law. Parts of the case were dismissed, so this is a partial survival, not a rout, but the core theory is headed to discovery. And discovery is where scraped data supply chains get deposed. And in Minnesota, the first ban in any U.S. state on AI nudification apps took effect on Saturday after a federal judge declined to block it, noting a little pointedly that XAI had waited nearly 3 months to claim the matter was an emergency. The message underneath the docket: states are not pausing AI statutes while the constitutional arguments play out. 3 quiet assumptions. Labels are voluntary, scraping is defensible, offshore training is safe, 3 courtrooms, 1 week, and lest anyone read all this as the technology slowing down to wait for the paperwork and the machines had a weekend too, OpenAI teased an unreleased model it calls Astra, publishing machine-checkable proofs that it says resolve 10 long open mathematics problems, one of them open since 1999, for roughly $2,000 of computing time. The results are still pending independent verification, so hold the confetti, but the direction is not ambiguous. And Alibaba, the Chinese commerce and cloud giant, shipped its newest Qwen model claiming frontier-level performance at a fraction of U.S. prices, and its shares jumped about 7% on the day. The law did not arrive despite the capability curve. It arrived because of it. Here is my read. AI regulation did not accelerate this week. It landed, and it landed the way modern rules actually land. Quietly, on a Sunday with per-day arithmetic attached while everyone watched something louder. The gap between we are watching the regulatory landscape and we hold a dated obligation closed over a weekend. The companies that notice this week get an operations task. The companies that notice later get a legal event. Same facts, very different invoice. So if I were sitting in your seat this week, I would do exactly one thing, and it is deliberately small. Put your general counsel and your chief marketing officer in the same room and ask one question: which of our customer-facing AI surfaces reach Europe or California, and whose signature is on the label decision? One question, one owner. The fine print can follow once somebody owns it, because the deeper truth here is in the choreography. Nobody synchronized those 2 laws. 2 continents wrote the same deadline without talking to each other, and your customers live in both. The lobbying phase ended on a Sunday. Compliance clocks do not send calendar invites. That is the YPO Tech Network AI brief for Tuesday, August 4th. I am Stephen Forte. If this was useful, send it to a fellow member. I will be back tomorrow with more. Until then, stay sharp.